In 32 years of working at the San Diego County Medical Examiner's Office, one veteran toxicologist had never once been asked to count the drugs, not the sealed envelopes of narcotics brought in from death scenes, not the vials of pure pharmaceutical standards kept for chemical comparison. The office was a federally registered handler of controlled substances, sitting inside a county government building, staffed by scientists whose entire profession was measurement, and no one had ever audited the shelves. That changed in December 2000. It changed because a 26-year-old man had died in an apartment in University City, and the people investigating his death had begun to suspect that the poison came from their own building. This is a case that gets told as a love triangle thriller. It's usually packaged around a movie reference and a photograph of an attractive defendant. But strip that away, and you find something considerably more useful and more uncomfortable. This is a story about how institutions fail quietly for years in ways nobody notices until a person is dead. It's also a story about how close this death came to being filed away and forgotten. The building. To understand what happened, you have to understand where Kristin Rossum worked. A medical examiner's toxicology lab is one of the few places in civilian life where large quantities of controlled substances sit within arm's reach of ordinary employees. Drugs recovered from death scenes arrive as evidence. Pure drug standards are kept on hand so analysts can compare a mystery substance against a known one. Both categories are regulated federally, and the office held a Drug Enforcement Administration registration that required it to maintain effective controls against theft. According to testimony later given under oath in civil court, here is what effective controls looked like in practice. Impounded evidence envelopes were dropped into a locked box. When that box filled, and it did fill, the overflow envelopes were simply stacked next to it, where anyone with access to the offices could reach them. There was no witnessed inventory when investigators dropped material off. Once envelopes moved into the toxicology lab, keys to the storage cabinets were available to every toxicologist on staff. Nobody logged who took what, or when, or why. That's not a scandal in the tabloid sense. It's something duller and more common, a system built on the assumption that professional people don't steal. Most of the time, that assumption holds. The interesting question, the one this case forces, is what happens on the day it doesn't. The two people Kristin Rossum was hired at the medical examiner's office in 1997 as a student worker still finishing her chemistry degree. She was promoted to toxicologist 1 in March 2000. Two things about that promotion matter enormously, and both come straight from the record. County policy at the time required applicants for that office to pass a drug and alcohol test. The job description for toxicologist required a law enforcement background investigation. Rossum received neither. An administrative manager thought she should be tested and was told by human resources it wasn't necessary because she already worked there. The same manager asked whether a background check was needed and was told it wasn't. Rossum signed a waiver consenting to both. Neither was ever arranged. She had a juvenile record involving controlled substances and a history of methamphetamine addiction dating to high school. The office knew none of it. Here's the nuance that most retellings skip, and it's important for fairness. There is no evidence she was using drugs when she was promoted. Her performance was strong. Her appearance gave nothing away. The evidence suggests she didn't relapse until late September 2000, 6 months after the promotion. So the screening failure didn't put a using addict into a drug vault. It put a person with a history of addiction into a drug vault, unsupervised, and then waited. Greg de Villers was 26, worked for a biotech company, and by every account from people who knew him, disliked drugs to a degree that would later become one of the most significant facts in the case. He and Rossum had met in December 1994 when she left college without telling her parents and went to San Diego to hide a relapse. He helped her get clean. She re-enrolled, majored in chemistry, and graduated with honors. They married in June 1999. You cannot understand the dynamics of what followed without sitting with that for a moment. The relationship began as a rescue, and rescue relationships carry a particular gravity, a debt structure, an imbalance, a sense on both sides of who is holding whom together. When the person who was rescued begins to change, the arrangement doesn't simply end, it fractures. 5 days, Michael Robertson arrived at the office in the spring of 2000 and became Rossum's supervisor. By May, co-workers suspected the two were involved and complained to management. Watch what happened next, because it's a small masterclass in how organizations avoid knowing things. The complaint went up the chain. A manager questioned some co-workers who, asked directly about their boss, denied seeing anything. He asked Robertson twice whether he was involved with Rossum. Robertson denied it, and that was the end of the inquiry. Rossum herself was never asked. The email traffic between the two was never examined, though it sat on county servers the entire time. Every step there was defensible on its own. Collectively, they added up to an institution that had been told the truth and declined to find it. By October 2000, Rossum had relapsed. Robertson knew. County policy required supervisors to report workplace drug use. He didn't report it. That same month, the two traveled together to a conference of forensic toxicologists. Attendees received a journal that included a paper analyzing 25 deaths caused by fentanyl. Both of them already knew something else relevant. Their own office did not routinely test for the drug. On Thursday, November 2nd, Greg confronted his wife. He told her he believed she was using again and involved with Robertson, and he demanded she quit her job. If she refused, he said, he would tell her employer both things. Consider precisely what that threat meant. It was not primarily a threat to a marriage, it was a threat to a career, a professional license path, and, given what was allegedly happening with the office inventory, potentially to her liberty. The following night, the couple visited her parents. They noticed nothing wrong. On Monday, November 6th, Rossum called Greg's employer to say he wouldn't be coming in. At 9:22 that evening, she called 911 and said he had stopped breathing. Paramedics found him on the floor beside the bed. Red rose petals, still fresh-looking, were scattered around him. He was pronounced dead at 10:19 p.m. There was no note, the decision that saved the case. An autopsy was performed the next day by the county medical examiner himself, Dr. Brian Blackburn. His findings were more precise than the popular version of this story suggests. Greg had been dead at least an hour before paramedics arrived and had been stuporous or unconscious for a minimum of 6 to 12 hours before that. Marks consistent with injection were noted on the body, but neither the autopsy nor the first round of toxicology screening identified a cause of death. At that point, a county administrator, Lloyd Amborn, made a decision that deserves far more attention than it has ever received. He sent the specimens to an outside agency for testing to avoid any conflict of interest. It was the first time in his career he had done so. Think about how easily that could have gone the other way. The deceased was the husband of a toxicologist in the office. The lab that would normally run those samples was run by that toxicologist supervisor who, unbeknownst to Amborn, was also her lover. The default procedure would have handed the analysis to the two people with the most to lose from the result. Amborn broke the default. When he told Robertson about the decision, Robertson's reaction was described as shock. The outside results came back: acute fentanyl intoxication with oxycodone and clonazepam also present. The brother here is the part of this case that I think is genuinely the most instructive, and it has nothing to do with chemistry. The death was initially treated as a probable suicide. Rossum said her husband had been despondent because she was leaving him. There was no note, but most deaths by suicide don't leave one. On paper, in the first days, the file could have closed. It didn't close because Greg de Villers wouldn't let it. Greg's brother pressed the police. His argument wasn't forensic, it was biographical. Greg was not suicidal, he told them, and more to the point, Greg hated drugs. The idea that he had deliberately consumed a powerful narcotic was, to the people who knew him, close to absurd. One of the trial prosecutors would later tell the jury in closing that without Jerome's call, there might have been no trial at all. That sentence should be on the wall of every death investigation unit in the country. Death investigators work under enormous volume pressure. and every case begins with a working hypothesis drawn from the scene. A scene that reads as a suicide tends to get investigated as one, and confirmation bias does the rest. Ambiguous details get sorted into the folder that's already open. What breaks that cycle is almost never a laboratory. It's usually a family member who knows something the file cannot contain, not evidence exactly, but character, context, the knowledge that this particular person would not have done this particular thing. Families are often dismissed as unreliable narrators of their own grief, and sometimes they are. This case is a reminder of the cost of assuming so. What the counting found. Once investigators began to suspect the drug had come from the medical examiner's office, the audits began. The first looked for fentanyl. 15 fentanyl patches, impounded across 3 separate cases, were missing. So were the contents of a vial of the fentanyl standard. Rossum had been involved in all 3 of those cases and had personally logged in the standard. Robertson also had authorized access to everything stored there. A second and third audit followed in December and January, looking for methamphetamine and other substances. Impounded meth was missing from multiple envelopes. Standards for methamphetamine and cocaine were gone. Those 3 audits were the first inventory of impounded drugs conducted in that 32-year toxicologist's entire tenure. A 4th audit in July 2001 examined all evidence drugs and found quantities of clonazepam and oxycodone missing. The same 2 secondary drugs found at low levels in Greg de Villers' body. Separately, detectives found a prescription in Rossum's name, dated late September 2000, obtained from a physician in Mexico for a drug that metabolizes into methamphetamine. Rossum was arrested in June 2001, 7 months after her husband's death. The trial and the decision that shaped it. Rossum went to trial in the autumn of 2002, charged with first-degree murder, with a special circumstance alleging murder by poison. The case was overwhelmingly circumstantial. No one saw anything. There was no confession. Circumstantial cases are frequently misunderstood by the public as weak. Legally, they aren't. Juries are instructed that circumstantial evidence carries the same weight as direct evidence. What they are is architectural. Each fact is a load-bearing element, and the prosecution's job is to build a structure where the alternative explanations can't stand up. Access to a rare drug, motive, opportunity, knowledge that the drug wouldn't be caught by routine screening, and the specific missing inventory matching the specific chemistry in the body. The defense made a strategic choice that would haunt this case for the next decade. It conceded that fentanyl caused the death and argued that Greg had taken it himself. You can see the logic. Fighting the cause of death would have meant attacking an outside lab's results with the defendant's own expertise as the elephant in the room. Conceding it allowed the defense to fight on the ground it preferred: a despondent husband, a wife leaving him, a death he chose. But that concession quietly surrendered the strongest position available. It meant the trial was no longer about what killed Greg de Villers. It was only about who administered it. And on that narrower question, the prosecution had inventory records. Rossum testified in her own defense, a genuinely high-risk decision. Defendants who testify convert a trial about evidence into a trial about credibility, and they hand the prosecution days of cross-examination. She denied stealing drugs and maintained her husband had taken old medications himself. Meanwhile, both sides gestured at an empty chair. Michael Robertson had returned to Australia in May 2001, a month before her arrest, and never came back. Prosecutors treated the absence as evidence of a partnership. The defense treated it as a place to point blame that could never answer back. It is one of the stranger dynamics in American criminal trials. An absent person is the perfect witness for everyone because he cannot be cross-examined by anyone. On November 12, 2002, what would have been Greg de Villers' 29th birthday, the jury convicted. In December, Judge John Thompson sentenced her to life without the possibility of parole. About those rose petals. Now let's deal with the detail that gave this case its nickname, because I think it has distorted public understanding more than it has explained anything. The prosecution connected the rose petals around the body to a film Rossum was said to love, in which petals appear in a recurring dream image. A grocery store record showed she had bought a single rose. The press seized on it instantly, and the case has been marketed under that movie's title ever since. 2 observations. First, as evidence, the petals were never load-bearing. The case was built on missing inventory, toxicology, timeline, and motive. The petals were atmosphere, but atmosphere is what travels. It's the detail that makes a case memorable, and memorability gets mistaken for significance. Ask most people who know this case what convicted Kristin Rossum, and a fair number will say, the rose petals. Almost none will say, a July 2001 audit found clonazepam and oxycodone missing. Second, the framing carried a cost. Casting a defendant as a beautiful woman staging a cinematic tableau invites the audience to consume her as a character rather than assess her as a defendant. That cuts both ways. It can make a jury pool hostile, and it can make later serious legal arguments on her behalf harder to hear. The nickname flattened a case about institutional drug control into a story about a femme fatale. It's a useful lesson in how media framing selects for the vivid over the probative. The refrigerator. And now the deepest irony in the case. Among the allegations authorities later compiled about Robertson's conduct after the death was this: that he opened the container of autopsy specimens that had been left for roughly 36 hours in an unlocked refrigerator, and told colleagues the reddish coloring suggested cough syrup had played a role. Hold that alongside the appeal Rossum has pursued ever since. Her post-conviction argument is that the fentanyl levels in those samples were so extraordinarily high as to be inconsistent with a man who survived for hours, and that the samples may therefore have been contaminated after death, deliberately or accidentally. Her claim is that competent trial counsel would have tested the specimens for fentanyl metabolites, which can help distinguish a drug processed by a living body from a drug introduced afterward, instead of conceding cause of death outright. So the very laxity that allegedly enabled interference with the evidence became the foundation of the defendant's own bid for a new trial. An office that couldn't secure a refrigerator handed the case a permanent question mark. That argument came remarkably close to working. In September 2010, a Ninth Circuit panel held that her lawyers should have investigated the contamination possibility and ordered an evidentiary hearing. Then, the U.S. Supreme Court decided 2 cases, Cullen v. Pinholster and Harrington v. Richter, that sharply limited what evidence a federal habeas court may consider when reviewing a state conviction. The panel withdrew its opinion and, in 2011, affirmed the denial of relief. The dissent noted that the medical evidence in the case had been equivocal and the fentanyl readings unnaturally high. This is worth pausing on, because it's routinely misreported. A federal habeas court is not asking whether the defendant is innocent. It is asking a much narrower question: whether the state court's rejection of a specific constitutional claim was unreasonable. Judged on the record the state court had, Rossum did not lose because a court found her guilty again. She lost on the scope of federal review. Those are entirely different things, and the difference is invisible in most coverage. She remains at the Central California Women's Facility in Chowchilla, serving life without parole, and has consistently maintained her innocence. The 2 accountings that never happened. 2 loose ends outlived the verdict. The first is Michael Robertson. Prosecutors named him an unindicted co-conspirator. Investigators traveled to Australia in 2003 to develop the case. He declined, on counsel's advice, to meet them. Then, on November 3, 2006, a single felony conspiracy count was quietly filed against him, along with a sealed arrest warrant, alleging he worked with Rossum to obstruct the investigation, and listing 77 overt acts, including hundreds of phone calls between the 2 in the weeks after the death, and further calls after he told investigators the contact had ended. The filing was never announced. Journalists who asked were told nothing. The victim's family didn't learn of it until a reporter uncovered the court file in 2013, 7 years later. No extradition has been sought. Robertson has always denied involvement, and it must be said plainly, he has never been tried, never been convicted, and is entitled to the presumption of innocence. The second loose end is the county. Greg's family sued, arguing negligent hiring and supervision and a failure to safeguard the drugs. A civil jury agreed on both theories and awarded damages. In 2007, a California appellate court reversed the entire judgment, not because the facts were wrong, but because California law bars direct tort claims against public entities unless a specific statute creates the duty. The federal drug security regulation the court held sets goals rather than commanding specific acts, and wasn't designed to prevent this particular harm. A jury found the county responsible. The law said the county could not be. Both statements are true, and the gap between them is where the family was left standing. Why this case still matters. In 2000, fentanyl was an obscure hospital opioid that a county lab didn't routinely screen for. That obscurity is precisely what made it useful. Today, it is the defining drug of an overdose crisis, screened for as a matter of course, and the specific advantage exploited in this case has largely closed, but the underlying vulnerability hasn't. Forensic laboratories, hospital pharmacies, veterinary practices, hospices, any institution where controlled substances meet human beings under stress, runs on the same quiet assumption that credentialed people don't divert. Audits, key control, witnessed inventories, and honest handling of relationship disclosures aren't bureaucratic fussiness. They are the difference between an institution that can detect a problem and one that can only discover it afterward, in a courtroom. The warning signs in this case were never really about a murder. Nobody could have predicted that. They were about a promotion that skipped its own required checks, a supervisory relationship reported and then unexamined, a policy violation a supervisor chose not to report, an inventory nobody counted in 3 decades, and a refrigerator nobody locked. Every one of those was visible before November 6, 2000. Every one of them was somebody's job. If a workplace had followed its own written rules, the drug test, the background check, the audits, the conflict of interest policy, would this death have been prevented, or would it simply have happened another way? Where does institutional responsibility end and individual responsibility begin? Cases like this remind us that some questions continue long after the headlines fade. If you found this documentary informative, consider subscribing for more carefully researched true crime stories. We'd also love to hear your thoughts in the comments below. Thank you for watching, and we'll see you in the next documentary.